So now we are going to talk about the federal acquisition system. This is how we can hold contractors accountable. We can recommit to the Federal Acquisition Regulation, the FAR, and to the Federal Acquisition Workforce. This is what provides accountability in our federal procurement system. So in addition to statutory limits on how agencies can procure items, agencies themselves have issued regulations that limit their procurement powers. And we primarily find this in the FAR, Federal Acquisition Regulation. It is our federal procurement code. It is in Title 48 of the CFR, Parts 1 through a lot. And the FAR creates uniform policies for agencies when they're purchasing goods and services. It's designed to ensure transparency and accountability, and the FAR is maintained jointly by the Secretary of Defense, the GSA Administrator, and the NASA Administrator. Additionally, most agencies have specific FAR supplements. So for instance, there is the DFARS, which is the Defense Federal Acquisition Regulation Supplement. Now the FAR is designed for contracts, not for grants or cooperative agreements. Those are governed by what used to be a series of OMB circulars, now called the Super Circular, unofficially. Its official name is the Uniform Guidance, and those regulations are in Title 2 of the CFR, Part 200. Uniform Guidance is substantially similar to the FAR, but it's a little bit more friendly because grants and cooperative agreements tend to be, well, as the name implies, more cooperative than a contract, which is more like a strict purchase. Many contracts are covered by both the FAR and the Uniform Guidance, depending on the type of contractor. So university contractors and nonprofits have to comply with both the FAR and the Uniform Guidance for contracts, but only the Uniform Guidance for grants and cooperative agreements, whereas for-profit contractors usually just deal with the FAR. This is the FAR. The government used to print it, the government printing office, but they stopped in 2005. It's still available in book form from commercial publishers. You're going to pay about $100 for it. It's available for free as a PDF. It's so large that it actually requires 2 separate PDF volumes. And you can see I've measured it out. We've got about 2.5 inches. And these are onion skin pages, so really, really thin paper. The FAR is divided into 8 subchapters and 53 parts. I'm not going to bore you by reading all of these slides. You can pause the lecture and take a look. But I'm going to highlight some of these. The FAR covers conflicts of interest, which is incredibly important for the purposes of transparency. We don't want to revert to a system where contracting officers are awarding contracts to their friends and families or to their own businesses. And although not governed by the FAR, many states have similar procurement regulations that prohibit financial and other conflicts of interest. Now, you might be aware of faculty startups at universities. There's usually a carve-out for conflicts of interest that relate to research so that faculty researchers can create these startup companies. And this is okay with the federal government because these startups usually commercialize the results of federally funded research, so they get them out into the public sphere. So the FAR's conflict of interest guidelines say that nobody in the government can personally benefit from the acquisition process, hence the issues with the Trump Hotel in DC. The FAR also covers acquisition planning, which is incredibly important and we'll talk about in just a moment. The FAR has an entire section on socioeconomic programs, and this is because the government uses its purchasing authority to advance certain socioeconomic goals, such as small business ownership, environmental protection, and awards to veteran-owned businesses, women-owned businesses, and minority-owned businesses. There are a variety of other contracting requirements, including special consideration for intellectual property created with government funding. The government's got to have the right to use that intellectual property, and it often asserts ownership of it. However, for those of you who are going to work at universities and nonprofits, there's a law called the Bayh-Dole Act, and that requires that the university or nonprofit is the one to own any intellectual property that comes out of government funding on grants and cooperative agreements. The government just gets a license to then use that intellectual property. The FAR talks a lot about proper contract management, and then it has its clauses and forms in Part 52. Part 52 is a big one. It's all of the terms and conditions that make their way into solicitations and into the contracts themselves. So complying with Part 52 is a really big deal for contractors. So almost all agency personnel touch on contracting at some point during their jobs, but there are roles for specific contracting personnel. So there is what we call the head of contracting activity. This is usually the head of the agency, and he or she is only rarely involved directly in procurement. Instead, the head of contracting activity usually delegates authority, procurement authority, to contracting officers. And contracting officers are the only people with the authority to bind the government to grants and contracts. So they're the only ones who can sign or modify contracts on behalf of the government. COs, contracting officers, they have dollar limits on their authority. We now call it a certificate of appointment, but it used to be called a warrant, and it would let you know, all right, you've got a $10,000 warrant, you can award contracts of $10,000 or less. The contracting officer is assisted by contracting officer technical representatives who do not have any authority to modify the contract. They're just there to assist the CO. And then there are also program officers. And these are agency personnel who are involved in the substantive work, so not the contract administration side. But they often work with the contracting officers because usually the contractor needs both substantive guidance from the program officer and administrative guidance from the contracting officer. So there are a variety of types of purchases that the government can make, broken down by dollar amount. So you've got micro purchases that don't exceed $2,500 for services or $3,000 for supplies. You've got small purchases that don't exceed the simplified acquisition threshold, which is currently $100,000. It'll probably go up soon, and that's for most contracts. It's higher for very specific contracts. Purchases that the government makes between the micro purchase threshold and the simplified acquisition threshold are supposed to be made to small businesses. These are small business set-asides where the government tries to award contracts to small businesses, women-owned businesses, minority-owned businesses, veteran-owned businesses, disabled veteran-owned businesses, and so forth. There's also a commercial item acquisition. This is what allows the government to buy ashtrays, off of Amazon instead of issuing a 9-page solicitation. Commercial item acquisition is great because the government doesn't have to jump through as many hoops. And basically, if you as an individual can buy something off the shelf, so can the government. There's also a variety of types of procurements. So there are Federal Supply Schedule, FSS contracts. The GSA compiles lists that they call schedules of commonly used supplies and services. They usually negotiate a discounted rate. These are usually for commercial items or services, and it basically allows agencies to pick off of a government wish list rather than go through the time-consuming process of issuing their own invitations for bids or requests for proposals and then vetting the contractors. So instead, the GSA's website allows a purchase with the click of a mouse, just like you or I would get on Amazon. Now, other types of procurements are fully competitive, and these are either sealed bidding or negotiated procurements. which we'll talk about momentarily. But I want to say a word about sole source procurements. The government is only supposed to use a sole source procurement when there is only one good source of the good or service required. So there's only one contractor who can actually provide what the government needs. And sole source procurements have to be documented by justification and approval letters. And lack of planning does not count as justification. So if it's an emergency because the contracting officer hasn't planned properly, it cannot be sole sourced on that basis. When agencies do procure as a sole source, they go straight to one company and they ignore the competitors. But before they do that, they have to publish an intent to procure in the Federal Register, and they have to review bids submitted by any competitors. And it's in the sole source area where we really get the breakdown of implementation versus policy. So there are two types of competitive procurement, so not sole source, and these are sealed bidding and negotiated procurement. In sealed bidding, the agency issues an IFB, that's an invitation for bid. Any contractor who's interested submits a bid. At the time prescribed in the IFB, the agency publicly opens all the bids, and whoever is the lowest bidder gets the award. So in sealed bidding, price is the only thing that matters. If an agency has to consider factors other than price, then it goes with negotiated procurement and issues a request for proposals, or an RFP. And the RFP sets forth all kinds of requirements and criteria that the agency will use to evaluate those proposals. So once contractors submit proposals, the agency opens them privately. So it's not the public opening that you have for invitations for bids, because proposals often contain confidential company information. And then the agency will hold a discussion with the handful of contractors that fall into what the agency deems the competitive range. And then it allows those contractors time to kind of go back, think about the discussion, and then provide a BAFO, that is their best and final offer. And then the agency awards the contract to the contractor whose offer is best for the government when considering price and other factors. So sealed bidding and negotiated procurement is how the agency decides how it wants to kick off the contracting process. Then it has to figure out the type of contract it wants to issue. And those are fixed price or cost reimbursement. Fixed price is exactly what it sounds like. The government sets a price in stone, and that's all they're going to pay. So the risk of any type of cost overrun is on the contractor. Fixed price is good for low-risk contracts where the cost is well known in advance and where the circumstances probably aren't going to change. Cost reimbursement, on the other hand, is better for more complex procurements where the agency's needs might vary, problems might not be foreseeable, or the agency thinks the scope of work might change depending on variables beyond its control. So often, if you think about like research and development contracts, it's hard to get a good idea on how much something might cost if you've not done the research yet. So that's why these are issued as cost reimbursement. The contractor spends the money as required to do the work and then gets reimbursed by the agency. Now, usually there is a ceiling for cost reimbursement. If the agency thinks it should spend, $200,000 and a contractor winds up spending $2 million, the agency is very unlikely to reimburse the contractor for the full $2 million. But legitimate cost overruns, they do have to be paid for by the agency. There are a variety of different types of cost reimbursement contracts. Commercial companies usually get cost plus fixed fee. That fee is the profit. So they get reimbursed for all their expenses, plus they get a profit. That fee is negotiated at the time the contract is negotiated, and it cannot be adjusted. Universities and nonprofits rarely get these types of cost plus fixed fee contracts because they're not supposed to make a profit. There's also a cost plus incentive fee, pretty much the same as the cost plus fixed fee, except that the fee can vary, so it's not fixed. There's a minimum and a maximum that you get negotiated when the contract is being negotiated, but the actual fee that the contractor receives is based on a formula. So they'll get a bigger fee if they exceed performance targets or meet deadlines. There's this formula that gives that fee. Then there is the cost plus award fee. Similar to the other ones, except it's completely up to the agency to grant the fee depending on how happy it is with the work. No minimum, no maximum. Totally at the discretion of the agency. There used to be a cost plus percentage of cost where the contractor was reimbursed for all expenses and then also got paid a fee related to the percentage of cost. So the contractor got paid more as the cost increased. And this type of cost reimbursement contract was prohibited because contractors obviously have no incentive to keep costs down if the fee they're getting is dependent on how much they're spending. Now, these cost plus contracts are particularly problematic for private military contractors and for emergency assistance contractors. And that's because it's just not possible to foresee all of the conditions in the field, either battlefield, natural disaster. And the contractors are entitled to additional costs if the scope of work changes. So these cost plus contracts can become expensive for the government, but they are often necessary just because there's no other good way to get the contractors in there doing the work that needs to be done. So this slide has the procurement cycle. So this is basically the life of an individual contract, assuming that there are no disputes that require litigation. And the cycle begins when an agency recognizes that it has a need to procure a good or service, and it ends with the end of the contract and contract closeout. And it's got all these steps in the middle. And a lot of these are acquisition planning. And the number one reason the government gets sued by government contractors is lack of good acquisition planning. Because that's the stage where the agency determines the factors it's going to use when reviewing proposals. Then it will, issue its IFB or RFP, hold negotiations, it'll issue a notice of intent to fund to the successful contractor. Then it can take many, many months to negotiate a contract. I have worked on contracts where it has taken over a year from getting the notice of intent to fund to actually getting the signed contract so that we can start work. Then agencies have to monitor contract performance and then pay the contractor, obviously, and then close out the contract after all of the deliverables have been delivered and all of the reports have been filed. Acquisition planning. This is the main reason that the government gets hauled into court by irritated contractors who believe that they submitted the better proposal and got screwed out of the contract because the government engaged in poor acquisition planning. The complexity of the acquisition planning process is obviously going to be dependent on the complexity of the procurement. So agencies have to start by figuring out their cost threshold. And the entire process gets more complicated as the cost gets higher. So agencies then review their buying patterns, determine how the agency handled similar procurements in the past. They can use what's called a blanket purchasing agreement if they've got continuing needs to be filled over time. So the successful contractor gets the BPA, the blanket purchasing agreement, and then the government just submits purchase orders when it needs something. Also, during acquisition planning, the agency has to determine if the FAR requires that the agency use certain contractor sources or certain contractor types. We've got federal prison industries, vendors who hire blind and disabled persons, small businesses. There might be some mandatory contract types or sources imposed by the FAR. Agencies also then have to consider the degree of competition that they can expect. So for instance, if the DoD is procuring a new type of fighter jet, they should expect proposals from Boeing, Lockheed, and Northrop Grumman. If procuring computers, the GSA, for instance, might expect proposals from Dell, Lenovo, HP, and Apple. So then after they determine source selection criteria, they've got to figure out what is most important to be considered when they are selecting a contractor, and the agencies have to have evaluation factors and weight them so that they can actually make a meaningful comparison of proposals. So they do this market research, they do a risk assessment, they prepare the statement of work. That is the who, what, when, where, and how of the contract. It's got to include measurable outcomes and deadlines, and it's got to be specific enough that contractors can provide an informed bid or proposal. All of this information from acquisition planning goes into a written acquisition plan, and this is what covers your ass if the agency gets sued. So the acquisition plan has to include everything on this list. State the agency's need, background information, FAR requirements, expected costs. Got to document any trade-offs, which helps when a lower priced bidder sues because they didn't get the contract. If you've got documented trade-offs at the agency is more likely to win the suit. Milestones, potential sources so that you get an idea of the field of competition, source selection procedures. All of this information goes into the plan. And the agency has to have a source selection committee to oversee all of this. So if you are ever involved in an acquisition, pull up this slide and make sure that you have checked all the boxes, because it'll provide a lot of legal protection from bid or award protests. So once an award is made, the contract is negotiated and signed, contract administration becomes really important. And this is where contracting officers and their technical reps are vital to the process. This is also why the current lack of a well-trained, balanced federal acquisition workforce is becoming a real problem. At a minimum, in the simplest of contract administration, the contracting officer accepts deliveries and pays the contractor. Because of sort of the atrophy of the federal acquisition workforce, right now, even this really simple form of contract administration can be problematic because contracting officers often just have too many contracts to administer. So even if it's a simple, yes, the contractor gave me my item and yes, I paid them, if you've got 3,000 contracts per year, it's going to be hard to properly administer all of them. And then, of course, contract administration becomes more complex if the agency has to engage in performance monitoring, performance audits, or financial audits. And these require a full contract administration plan so that the agency can efficiently review contractors' performance and pay off those invoices. And proper invoices are required before the government will pay the contractor. And again, these can be really simple invoices, like with line items for commercial products, or they can be a lot more complex, with a lot of detail on effort reporting and a variety of financial certifications. COs can also modify contracts. COs can request audits from financial organizations within the government. For instance, the Defense Contract and Audit Agency, DCAA, will come in and audit a lot of contracts to make sure that the contractors are using appropriate accounting systems, just making sure that basically everything is above board. I have to say, as somebody who works with DCA a lot, I'm not terribly impressed by a lot of their auditors. They get a lot of auditors who are really green, they're new, they don't exactly know what they're doing. It can be particularly difficult because DCA auditors often work with for-profit companies, and when they have to switch to a nonprofit contractor like a university, a lot of times they become confused on the regulations that apply, and so there's a lot of sort of educating your DCAA auditor. Contracting officers can also terminate a contract, either because the contractor has done something wrong, so that's a termination for cause, or they can terminate for the convenience of the government, unless it's the GSA with the Trump Hotel. And then contracting officers also handle claims, disputes, and a variety of protests. So disputes can arise for a variety of reasons. It's possible that the contractor went above and beyond and expects an equitable adjustment to get paid more. It's possible the contractor charged the government for something and the agency says that's not an allowable cost. The contractor thinks it is an allowable cost, so there might be a dispute over payment. When a contractor submits a claim, it has to be in writing and it has to be quite specific. And it also needs to include a certification. It's almost like a lawsuit, like what you would file to kick off a lawsuit. So filing a claim can be quite challenging, and a lot of times contractors rely on law firms to handle this. The contractor and the contracting officer will try to settle these disputes via informal negotiation. If that isn't possible, the contracting officer will issue a written final decision that basically sets forth the claim or dispute and gives the contracting officer's decision on it with the contracting officer's rationale. And this always includes a notice that the contractor can appeal. So there's a law called the Contract Disputes Act, which, as the name implies, covers disputes on contracts. So at any time, the contractor and the agency can go into ADR. It's alternative dispute resolution. Otherwise, the contractor has two options to appeal from a contracting officer's final decision. Within 90 days, the contractor can appeal to the Agency Board of Contract Appeals. Within 12 months, the contractor can appeal to the Court of Federal Claims. The choice is binding, so if you appeal to the Agency Board of Contract Appeals, you then can't go to the Court of Federal Claims later. However, either option, if the contractor is unhappy with the result, can be appealed to the U.S. Court of Appeals for the Federal Circuit. By the way, the U.S. Court of Appeals for the Federal Circuit, it appears to be a real court. It's got a fancy court building and everything, but it is actually an Article I legislative court. Contract closeout. This is the final step in the process. The contracting officer makes sure that everything was done to the agency's satisfaction, all the proper reports were filed, if the government furnished any items, those get returned, does all the final payment, and then the contracting officer issues a contract completion statement, and then both the agency and the contractor keep those records, usually for 7 years. So that is the end of the acquisition process. That is the final life of the procurement cycle.